We have an amazing panel here, some of whom have traveled, from very, very far from England, and they're here to share their experiences with us, and we are so happy to have them. So let's give them a warm welcome. And I'll turn it now to our moderator, Mr. David Rivkin.
It is a fascinating subject. Everybody would speak for 8 minutes. Then we'll have half an hour of Q&A among the panel members, which I will direct, and then we'll open up to questions. And the sort of only substantive point I would mention at this point in time is that in addition to the way the lawfare impacts the debate and the battle of ideas in Europe at the UN, although we forgot to UN, it's probably a misnomer, Europe has, because of the ability to sue American-based actors based upon fairly tenuous jurisdictional grounds, the lawfare directed out of Europe very much reaches into the United States and has been used as a way to silence many vibrant voices. So hopefully we'll go through those issues in some detail. So we'll go.
Well, thank you very much to the legal project of the Middle East Forum for this, and Brooke Goldstein and Daniel Pipes for the terrific initiative that this represents. To introduce myself, perhaps the best way is simply to say that my name is David Harris and I'm a recovering lawfaree. It seemed appropriate that it was for remarks made on the 1st of April that I was sued in defamation by the Council on American Islamic Relations Canadian chapter, CARE-CAN. It was surely one of the more legally meritless of hardline Islamist, if you will, April Fool's jokes. CARE-CAN's suit against me started after a 2004 broadcast on Radio CFRA in Ottawa, Canada's capital. Interviewer Steve Madeley and I spoke on air of the double discourse, familiar to so many of you here as radical Islamist technique of oozing seductive brotherhood in interfaith and other public forums, whilst privately conveying something less gentle to cronies and co-conspirators. I urged media and other opinion makers to go beyond Muslim lobbyists, reassuring public noises, and ensure that only genuine moderates were represented in the media as such. I pointed to what I identified as a US organization, CARE, and mentioned that it had seen several officers and close associates jailed on terror-related convictions. And I was probably thinking in this of folk like Randall Royer, the Muslim convert who was the explosives and ammo-packing CARE communications specialist and civil rights coordinator. I told the interviewer that a similarly named group, the Canadian Council on American Islamic Relations, CARE-CAN, existed in Canada, and that its chair, Dr. Shima Khan, had started a periodic column in Toronto's Globe and Mail newspaper. In light of the influence and legitimacy this might confer, it was important, I said, to recognize, and I quote, that there is some sort of obligation on the part of the Globe and Mail to at least clarify where exactly CARE Canada fits in this larger picture, unquotes. Well, for this, ladies and gentlemen, I was sued. As a lawyer later put it, I asked a question and got a lawsuit in response. The statement of claim of Khan and CARE-CAN was unusually hysterical, even by CARE standards, insisting that I had linked the organization to terrorism. As tempting as it might have been for lesser beings, I had not myself done so. But I had to be silenced, for as the Holy Land Foundation matter would later reveal, I was obviously moving along an inconvenient trail. A 2-year farrago followed in which CARE-CAN absurdly pretended that they had nothing very substantial to do with their own US mother organization. This farce collapsed under a mound of evidence, not least the discovery of an affidavit Dr. Khan herself had sworn only months before my broadcast, in which she declared that CARE exercises direction and control over CARE-CAN. Then it was reported that Dr. Khan had sat on the US CARE's board while she was a senior CARE-CAN operative. Well, in the end, we forced CARE-CAN to settle. As Maclean's magazine reported at the time, CARE-CAN folded its suit, and I quote, with no damages, costs, apologies, clarifications, or cab fare. But I came out of this with some important lessons. First, attempts to silence must be fought for a good and sound constitutional reason. But for other reasons, concessions are not an option with adversaries like CARE. Everyone knows that CARE can, is unreliable in its phantasmagorical and divisive claims of Muslim victimhood. But this is merely part of a larger ends justifying the means approach that makes it pointless to make concessions with them in any legal settlement, for concessions would only be misrepresented by such groups. Now recall that for all of CARE's breastbeating, it abjectly surrendered, in my case in 2006, and took home nothing. But this did not stop them from changing the subject and concocting a misleading news release. There they crowed that once their lawsuit hit, I appeared never again to be used by CFRA radio as an on-air intelligence analyst. Now this was wrong and highly revealing about the motive underlying their suit, for I continue as a broadcast guest to this very day. Now, 3 years later, the uncorrected news release remains on the CARECAN website, evidence of, and you may quote me, deceit and disinformation. You simply cannot make a deal with this bunch. Which is why defendants in this sort of outrage must stick to their guns, ensure their cause gets publicity, and sign, above all, no confidentiality agreement that would prevent the public from judging what has gone on. Publicity is important in the process, for during the North American suits, CARECAN was able to profit from the one-sided advantage wrought by silencing. Stifling opposition allowed them to make quiet overtures to respected, if unsuspecting, organizations in possible hopes of rescuing CARECAN's brand from revelations of its radical US origins and from its own refusal to condemn by name Hezbollah, Hamas, and certain other Islamist terror groups. During CARECAN's free speech offensive, the Canadian Bar Association, for example, ordinarily a protector of constitutional rights in Canada, stumbled into putting CARECAN chair, Shima Khan, onto a lawyers' national continuing education conference panel, mainly on the grounds that Khan wrote for the Globe and Mail. In a stunning follow-up, Dr. Khan and her outfit reaped credibility from being elected to the Canadian Civil Liberties Association, traditionally a defender of free expression. This, while CARECAN was connected to a transcontinental lawfare assault on anti-jihadist free speech. Conversations with CCLA officials at the time suggested that they had had no idea what they were dealing with, and the CCLA never admitted a blunder that prevented people like me from seeking their help and assistance. Also during the period, the Canadian Association of Security and Intelligence Studies, a quasi-academic organization that would be expected to value free speech and maybe know something about radicalism, invited Khan to serve as a conference panelist. Well, except for the Globe, most of these groups have now backed off CARECAN connections. A tragic exception is Amnesty International's English-Canadian section, once a leader in human rights, but now holding silent about this lawfare and shocking the conscience of many Canadians by appearing to deepen its involvement with CARECAN, among other questionable groups. This involvement came to note when so many of us were struggling for First Amendment and Charter Section 2 freedoms that might have been thought to have been of some interest to Amnesty International. As a once proud member of Amnesty International, I cannot sufficiently express the dismay and sense of betrayal lawfare survivors are entitled to feel. Suffusing all this is the importance of suitable legal representation. And thanks to the generous efforts of the Legal Project of the Middle East Forum and others of today's sponsors, people placed as I was can hope for legal assistance. We need the equivalent of a call-up of my fellow patriotic lawyers willing to do their national duty in this war at home. Some Islamists have now moved on in Canada to silence truth-tellers by using the arbitrary power of certain Canadian Human Rights Commission's statutory mandates. It's imperative that Canadians amend any commission mandate that could serve Islamist lawfare, and that Americans take serious note of these trends north of the border. In the process, of course, it will be vital to remember and guard against future abuse of our court system, whose libel law remains a weapon in aggressive hands. This law should be tailored to deal with the lawfare dilemma, perhaps through a new legal understanding of the concepts of frivolousness and vexatiousness. In 30 years of involvement in security and intelligence affairs, I've never been more concerned about internal threats to our security and to our liberties. But I began these remarks with humor and will close on a wry note. At the height of their free speech offensive, CareCan operatives did a quick step when news broke that they were defendants in the New York 9/11 lawsuit that's going on. Well, how did they explain this? A hand-wringing CareCan executive director blamed it all on a scurrilous attempt to silence them by, well, lawfare, a slap suit. Now, I ask you, April Fools or not, who says Islamists lack a sense of humor? Thank you very much, ladies and gentlemen.
Yes, thank you, David, indeed. I think your dulcet tones remind us of why radio is the preferred medium. I can now say I'm a long-time listener, first-time fellow panellist. My name's Alan Mendoza. I come to you from the UK. I represent a British think tank called the Henry Jackson Society. Indeed, it was a delightfully arduous journey over, as anyone who's ever transferred through JFK knows. Closed terminals, illegal sort of liquids in bags, all kinds of things designed to frustrate. But I'm delighted that the Legal Project, the Middle East Forum, have put this conference together. I very much enjoyed this morning's panels, and we'll look to contribute our own part now on matters in the EU. And the substantive part of my discourse will indeed be on lawfare in the EU, excluding the UK. But before I get into that aspect, I think that a word or two is required on the UK legal system, and to the extraordinary circumstances where the Mother of Parliaments has stood idly by as a succession of litigious individuals of Muslim origin have filed lawsuits in order to prevent discussion of radical Islam. How have things come to this, where the freedom of Albion is being undermined to the extent where a foreign body, the state of New York, has felt it necessary to invoke statute to nullify that of a democratic nation? Well, the simple answer, as you heard this morning, lies in the nature of British libel law code, which makes the UK a uniquely attractive proposition for a libel litigant bringing a claim against a defendant. Now, before I delve into the legal minutiae, I feel a confession is in order. I am not a lawyer. A second confession, I do not wish to become a lawyer. However, some of my best friends are lawyers. Unfortunately, some of my best friends have also suffered as a result of lawfare, and through the combined efforts, I've come to understand something of it. And the point I'm trying to make is that while legal issues are often confused by obfuscating language, in this instance, the problem of lawfare is strikingly simple. And if a layman like I can understand it, and I don't mean this in a disparaging sense, our legislators in the UK can also understand it. That is, of course, if they can tear themselves away from their expenses scandal long enough. Now, the aim of libel law is, of course, a noble one, to balance the right of free speech against protection for the reputation of an individual against unjustified attack. Now, so far, so straightforward. And if anyone's ever dealt with the UK press, you'll understand there are very good reasons for why a balance has to exist. Privacy is often actually sort of ridden roughshod over. Some of you may know of a very recent case involving the McCanns, a family whose daughter was abducted on holiday, where their privacy was invaded to an unprecedented extent. Libelous stories made up about them having been implicated within this, so on and so forth. Of course, in cases like that, we understand there have to be privacy concerns and defences against libel law. But that said, not all cases are like the McCanns. And obviously, when it comes to cases like radical Islam, there are specific defences in British law which actually allow for what might technically be termed libel to proceed. So, contrary to what you might think, there are actually the ability of newspapers to cover issues like this. The Human Rights Act was passed in Parliament in October 2000, and newspapers since then have been able to point to Article 10, which gives a measure of protection for freedom of expression in the public interest. A publisher can utilise the notion of fair comment or can report a statement protected by parliamentary or legal privilege. But every silver lining has a cloud, and judges have proved only too willing to interpret Article 10 in an extremely narrow way. So in effect, it's been negated by judicial inaction. So if the organs of the so-called fourth estate, the media, have been muzzled, then we also have to be aware of the more common problems we face with UK lawfare. Firstly, and I'm repeating some of what was said this morning, the burden of proof, of course, does rest in the UK on the shoulders of the defendant, not on the plaintiff. Secondly, as shown in the Ehrenfeld case, there's a problem of jurisdiction and libel tourism occurring when a non-UK author repeating previously made statements to a non-UK market can be sued in the UK if even one copy or several have been distributed in the UK. Thirdly, there is a problem of gradation of scale in libel cases. You cannot just have been a little libelled in the UK. You're either libelled or not, and as a consequence, there's no sort of issue on the expenses either. They get ramped up. And this, of course, leads to the fourth problem of cost. A report by Oxford University found that the costs of defending libel claims in the UK are 140 times higher than in the rest of Europe. And part of this is bumped up by British libel lawyers who practice conditional no-win, no-fee statements, encouraging libel actions to occur in order to attempt to get their damages through. Now, of course, a defendant, whether large or small, end up facing the possibility of daunting legal bills, and they, of course, have no no-win, no-fee arrangements. It becomes very prohibitive to fight libel cases. Now, the net effect of these problems is that authors and publishers often feel little choice but to settle out of court. They apologise, they take remedial action of their own volition, or will not even print statements likely to prove controversial or which may provoke litigious individuals or groups to sue. While they may live another day to fight through this self-censorship, if it becomes dangerous to speak the truth, as it has become in Britain, then the truth will not be spoken. And if anyone is doubting that the beneficiaries of this situation are those who've been accused of links with radical Islam, again, we heard this morning of the case of the wealthy Saudi businessman Khalid bin Mahfouz, who resides in Saudi Arabia but has sued or attempted to sue 30 publishers and authors in British courts. So if that encapsulates a problem of libel law in Britain, what are the great landmass to our east, the countries of the European Union? Have they been spared the trials and tribulations that have affected Britain? Well, in one sense, yes. Because of Britain's uniquely welcoming libel law system, Europe has been affected by libel tourism to a far lesser extent. But it does suffer from a different form of lawfare, that being invoked of the notion of religious hatred laws, or the concept of blasphemy. In particular, Islamists have been able to use the legislation that criminalizes hate speech, certain forms of racism and xenophobia, for their own ends, and have been able to seek criminal action or libel damages as a consequence. Now, you'll all be aware of the most infamous example of European lawfare in the forms of the Muhammad cartoons controversy in the fall of 2005. 12 editorial cartoons, most of which depicted the Islamic prophet Muhammad in unflattering poses, were published in the Danish newspaper Jyllands-Posten on 30th September of that year. The newspaper announced its publication was an attempt to contribute to the debate regarding criticism of Islam and self-censorship. On 27th of October, a number of Muslim organisations responded. They filed a complaint with the Danish police claiming that Jyllands-Posten had committed an offence under two rather obscure sections of the Danish Criminal Code dealing with blasphemy and degradation of groups in society. This high-profile move was accompanied by violent and febrile protests by other Muslim groups across the continent and a boycott of Danish products by Muslim and Muslim countries worldwide. Now, incredibly, the fallout even stretched as far as earlier this year. The appointment of the new NATO Secretary-General, Anders Fogh Rasmussen, was actually held up by Turkey's objections to his selection on account that he had been Prime Minister of Denmark at the time of this controversy. So there's a long reach involved in these issues. Now, what's particularly incredible about this situation is that in January 2006, the regional public prosecutor in Viborg in Denmark discontinued the investigation. He found no basis for concluding that the cartoons constituted a criminal offence because the Danish code has public interest exceptions. However, this was a scant consolation to the journalists and government concerned, which had been harried into hiding or retreat by the threats of the mob. Now, if blasphemy was a tool of choice in Denmark, Italy's law against outrage to religion was used against the journalist Oriana Fallaci over her statements and writings on Islam. In 2005, Adele Smith, president of the Union of Italian Muslims, launched a lawsuit against Fallaci, charging that some of the things she said in her book, The Force of Reason, are offensive to Islam. Smith's lawyer cited a phrase from the book that refers to Islam as a pool that never purifies. Consequently, an Italian judge ordered her to stand trial in June 2006 in Bergamo on charges of defaming Islam. Now, due to Fallaci's death in December 2006, the case was not concluded, but a marker had been laid down. Another well-publicised case, of course, was that of Geert Wilders. We heard about that this morning. I shan't repeat it, only to say that not only did Wilders face the prospect of libel damages, imams were complaining their feelings had been hurt by his 10-minute film, but the sums they were claiming were a lot more than hurt feelings. But he was also, of course, rather controversially banned from entering Britain earlier this year on account of a peer of the realm threatening violence from British Muslims should he step foot in the country. Europe has, of course, also caught the disease from Britain of self-censorship. In September 2006, French writer and philosophy teacher Robert Redeker wrote an opinion piece for Le Figaro. In it, he attacked Islam and Muhammad, writing, "Pitiless war leader, pillager, butcher of Jews and polygamous. This is how Muhammad is revealed by the Quran." He called the Quran a book of incredible violence, adding, "Jesus is a master of love, Muhammad a master of hate." That day's issue was swiftly banned in Egypt and Tunisia, and the paper responded by removing the article from its public database. Redeker was less fortunate. He received various death threats from Islamist websites, and indeed he was sentenced to death on one, and photos of his house and his address were put on the internet. Threats with violence have also affected the cultural sphere. In 2006, in Germany, the Deutsche Oper, one of Berlin's 3 opera houses, announced the cancellation of a provocative production of a Mozart opera in the hope of avoiding potential Islamist terrorist attacks, which the police had said were imminent. The production would have included a scene depicting the severed head of Muhammad alongside those of other religious figures. So where are we now in terms of the European legal framework surrounding blasphemy and religious hatred? Well, in good news, despite calls by some European Muslim figures for blasphemy laws to be institutionalized across the EU to protect Islam from defamatory attacks, these have so far been rejected. However, others have been less determined in their approach. For example, as if the Enlightenment had never occurred, Ireland seems to be on a headlong rush back into the Dark Ages. Just last month, the Irish Minister for Justice, Dermot Ahern, proposed to insert a new section on blasphemous matter into the draft Defamation Bill being considered by the Parliament. Blasphemous matter was defined as a matter that is grossly abusive or insulting in relation to matters held sacred by any religion, not the state religion of Ireland, Catholicism, any religion. If this law passes, where will the boundary be drawn between legitimate criticism and blasphemy, free speech and outrage? Moving on to religious hatred. After lengthy negotiations, on November 28, 2008, the Council of the European Union's framework decision on combating certain forms and expressions of racism and xenophobia by means of criminal law was finally adopted. The decision obliges EU member states to criminalise, among other conduct, public incitement to violence or hatred directed against a group of persons or a member of a group defined by reference to race, religion, colour, descent, or national or ethnic origin. What this means is that EU member states now have the option of punishing conduct that is carried out in a manner likely to disturb the peace or conduct that is abusive, threatening, or insulting. This is, of course, how Wilders was prevented from entering Britain. Of course, I recognise, and I'm sure that all the panellists you hear today will agree, that there's no such thing as the absolute freedom to speak, and that there are indeed legitimate constraints on speech, such as obscenity, defamation, or incitement to immediate violence. But when hate laws are so selectively applied, when they are used to criminalise satire or opinion or to punish what is merely offensive to some, then they are being used to infringe the rights of the speaker, who is neither afforded any type of due process or equal protection under the law. Hate speech laws, short of incitement to immediate violence, are by their nature all-encompassing, arbitrary and capricious, and put the rights of religions ahead of individual liberties. The due process problem is that there is no objective standard by which to measure what is illegal. A person will never know if what they are saying is allowed or not until someone later finds it offensive. A democracy must only enforce laws by which citizens know in advance how to govern their actions, or we will live in a state of fear, oppression, and self-censorship. So if the picture is gloomy in Britain and Europe, we can at least take hope that there's a simple solution. That is, look to change the interpretation of legal codes. In Britain, That process has already begun. There was a debate on the subject of libel law reform, including an assault on libel tourism, initiated by 3 members of Parliament in December 2008. A parliamentary select committee has been looking at the aspects of libel tourism and media libel law. And Parliament will also be considering a draft civil law bill during the course of the next session, which can be used to investigate the matter further. And I'm pleased to say that the legal project of the Middle East Forum has played a strong part in this and continues to do so, together with organisations such as my own and Douglas Murray's Centre for Social Cohesion. But one thing is for certain. If we want change in Britain and the continent, we have to enact it ourselves. It's no good pulling up the drawbridge and retreating here to the safety of the USA through legislation, admirable as it is, of the type proposed by Senator Spector and Lieberman. This may stave off the problem for a while, but if we continue to adopt defensive tactics, it'll only be a matter of time before the Civil Liberties Brigade arrive on your shores. The USA under President Obama is already a changed place to that under President Bush, lest we forget. So let us join forces to defeat this international scourge. In so doing, perhaps we can give new meaning to that oft and well-worn phrase, the transatlantic alliance. Thank you.
In the shadow of several criticism of Islam through the courts, the OIC-sponsored United Nations resolution on combating defamation of religions has gotten a lot of press lately, but it is not new. The resolution has been introduced in various forums every year since 1999 by Pakistan on behalf of the OIC in the United Nations. It was originally introduced to the UN's Commission on Human Rights, and since 2005 has been introduced in the United Nations General Assembly and has passed every year. The first draft of the resolution in 1999 was entitled Combating Defamation of Islam. Some of us may not know this. It's not necessarily secret, but it's just not commonly talked about. Combating Defamation of Islam. Many delegates to the Human Rights Commission felt that the resolution wasn't being even-handed since it only addressed Islam, so the OIC amended it to refer to defamation of religions. But as it stands now, the resolution remains under-inclusive. While referring to all religions, the only religion identified by name remains Islam. The original purpose that the OIC cited for introducing this resolution was that defaming Islam leads to an increase in intolerance towards and violence against Muslims, a notion that was further reinforced by them after the attacks of September 11th, 2001. And despite the resolution's amendment to cover all religions, it presents Muslims as constant victims, specifically asserting that they are being singled out for denigration. The most recent example of this effort is the consistent juxtaposition in every resolution since 2001 of the alleged plight of Muslims with the attacks of September 11th, which strongly suggests a denial of culpability in those events, and the resolutions even go so far as to state in adjacent clauses that, quote, Islam is frequently and wrongly associated with human rights violations and terrorism. On its face, adopting a resolution that protects religions against defamation may seem like a benign undertaking at the very least, and perhaps even a good thing, because why would anyone logically be against protecting religion? But the resolution raises certain problems. Prohibiting what they call defamation of religion stifles free expression by preventing discussion of religious values in the marketplace of ideas. UN resolutions are non-binding and do not have the force of law, so a resolution on defamation of religions may not appear so worrisome. However, there have been attempts to make the resolution enforceable international law by way of a UN convention. This effort is essentially cover for the promulgation of Islamic blasphemy laws. There have already been efforts to prosecute citizens of Western nations for blasphemy in Islamic courts. Some of us have already spoken about Geert Wilders and the Danes, who've been sued. Their lawsuit was last year. The actions of the defendants that led to those charges were not committed in Jordan, and Denmark and the Netherlands did not extradite their citizens to stand before the Jordanian court because the alleged crimes these individuals committed were not crimes in those countries. On the contrary, they were actions guaranteed by those countries' laws which protect free expression. If the resolution on combating defamation of religions becomes international law, there would be no safeguards against prosecution of individuals who act within the rights afforded to them by the domestic laws of their home countries. Essentially, global free expression would come to a standstill when the subject matter pertains to religion, particularly Islam. This could result in prosecution without boundaries and the limitless exposure of every global citizen to censure. Now, as many in our field have already been doing, it's important to continue to speak about the dangers of the resolution to the Western values that promote free expression, values that have been delineated by the 1948 Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights of 1966. The Universal Declaration states in Article 19, everyone has a right to freedom of opinion and expression. This right includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers. The ICCPR states in various clauses, everyone shall have the right to freedom of thought, conscience, and religion. Everyone shall have the right to hold opinions without interference, but in Article 20 of the ICCPR, it says any advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence shall be prohibited by law. At the time the ICCPR was written, Eleanor Roosevelt spoke for the United States and said that Article 20 of the ICCPR would allow governments to silence all criticism under the guise of protecting against religious hostility, rendering other basic rights guaranteed by the ICCPR null and void. Now, it's important to note that criticism of religion is not the same as hate speech. Criticizing an idea and questioning its value is an expression of opinion and a right that is protected by the laws of free speech, but both in domestic laws of Western countries and in international law under the Universal Declaration of Human Rights and the ICCPR's earlier clauses. Under the Western understanding of the definition of defamation, defamation of religions would actually be legally impossible. Defamation involves the publication of a false statement about a person, business, group, or government. A religion cannot be defamed, as it is merely a set of beliefs. For the purposes of a defamation claim, the falsehood of a statement about a religion can never be established, because neither can its truth. By its very nature, a religious belief is subjectively determined by the religion's followers. Moreover, not only is it not the role of a judge to determine whether a belief is true or false, it is not possible to render a decision on a matter the very nature of which is inconclusive. So even if it were determined that an adherent of a particular religion could sue in the name of that religion, questions of proof would arise as to the association with that group, and the courts would be flooded with frivolous claims. Furthermore, due to the inability to provide empirical evidence of the religion's veracity or fallacy, not to mention the challenges relating to the questions of proper venue and issues of standing, a lawsuit based on defamation of religion is impracticable, and a claim arising from that cause of action would be unable to be presented in any reputable court. So the question remains, if there are serious legal challenges to the application of a defamation of religions convention, and Western countries that place a high premium on free expression see this resolution as contrary to their values, why should we worry if we can argue that it will never really apply to us at all? After all, just because a UN convention exists does not mean the US or any state must sign on to it. The answer is this. The term defamation of religions has entered the legal lexicon of the international community without people stopping to really think about what it means, what it legally entails, and what effect it could have on them as individuals and on the societies they live in. Some may support it without fully analyzing its implications. Ultimately, though, people will be afraid to speak their minds, critique ideas, or discuss certain issues for fear of being brought up on charges in the international system. We must continue to bring to light the inadequacies of a resolution on combating defamation of religions and point out the details that raise cause for concern. It is important to emphasize that as it currently reads, defamation of religions really remains defamation of Islam, code for Islamic blasphemy laws, and a cover for the intentions of the OIC to make criticism of Islam a criminal act under international law that has the potential to silence the masses.
My name is Barak Sina. I'm heading the Middle East Department of the Henry Jackson Society that is currently based in Parliament in Britain. Last night, just a bit of a precursor, last night, by the way, first I want to thank the Middle East Forum for inviting me here. Last night, Brooke was taking a look at my lecture. She looked at my notes, and she was like yawning, saying, "Oh God, Barak, this is really convoluted. It's really tedious. The first paragraph, people are going to fall asleep." So I just hope that the combination of my accent and your confusion with the convolution of this will make you substitute it for sophistication and intelligence. I want to transcend. I want Lawfare to I have also the pleasure of not being a lawyer, and I hope that I can attempt to transcend Lawfare from a localized, even state level, to a multilateral and globalized sphere, because it has numerous manifestations. We're now living in a globalized information age. That often sounds quite a cliche, but accompanying that is increasing networks of reality, and there's rapid flows across borders of refugees, populations, finances, etc. And thus, accompanying that, you've seen the rise of sub-state actors, corporations, and civil society, and this is just well beyond their traditional remit. And civil society consists of charities, coalitions, advocacy groups, and NGOs, and it's the latter that I hope to focus upon. It was often also a cliche to think that globalization would be accompanied with increased unification around the globe. There would be an end of history. There would be no more wars, heightened peace dividend. But what you saw accompanying globalization was heightened economic disparities between the north and southern hemispheres, as well as a resurgence of cultural and ethnic identities which have been accompanied by various conflicts. Globalization was also accompanied by a backlash against the West with the advent of transnational terrorism, also replicating what we have in the West for financial flows. They had flows of terrorism and nuclear proliferation. These are, however, only the hard-powered flows that harm the West's national security. More insidious are soft-powered networks in civil society that are wielded by jihadi organizations intent upon undermining the Westphalian state system. There are occasions when civil society do not simply legally represent or provide advocacy for terrorist entities, but have members that are actively engaged in terrorism. Mazhar Bashir, a Palestinian for Deir al-Balah in Gaza Strip, worked for the humanitarian organization Doctors Without Borders and met with a Popular Front for the Liberation of Palestine in September 2006 and was indicted for allegedly plotting to assassinate Prime Minister Ehud Olmert along with other Israeli political officials. NGOs in the past have aligned themselves with terrorists. In late 2007, 3 major NGOs, Human Rights Watch, the International Federation for Human Rights, and the World Organization Against Torture, published a joint press release calling on Israel to lift the travel ban placed on Shawan Jabarin, the General Director of Al-Haq. Jabarin was convicted in 1985 for recruiting members on behalf of the Palestinian Front for the Liberation of Palestine, which is designated as a terrorist organization in the United States as well as the EU and Canada. We hear this and we're taken by surprise. This is just one very brief example at the level of infiltration that jihadi organizations have managed to achieve at a multilateral level, which is where civil society exists. And we think that civil society is new, maximum a couple of decades old. Yet this globalized outlook remained a jihadi ideal for centuries in the form of a caliphate and ummah. And jihadists today are quick to capitalize on Western techniques at promoting such agendas. They've achieved this through the legal principle of universal jurisdiction, and I'm not going to touch upon that at all. I'm just going to mention a couple of cases that occurred. Israeli Major General Doron Almog, he wasn't able to enter Britain. As soon as he arrived in Britain, legal writ was issued against him and for committing a grave breach of Article 147 of the Fourth Geneva Convention. he had to remain on the plane and had to return to Israel straight away. This, of course, happened originally with Ariel Sharon in Belgium, and that lawsuit was translated into English by a couple of NGOs, one called LAW Law, another the Palestinian Center for the Protection of Human Rights and the Environment. The reason why I'm going into all these NGOs are they are actively operating on a European level. Now, Sharon was charged with crimes against humanity, genocide, and war crimes. One of the central NGOs behind indicting Israeli generals abroad have been the Arab European League, and the president of this, called Abu Jaya, right, did not deny the political nature of the case, stating we had to prepare on the legal level as well as the political, financial, and logistical levels. This NGO had termed the 9/11 attacks in the US as sweet revenge. Rantisi, Hamas leader Rantisi, was termed a great leader of resistance. And concerning the war in Iraq, the AEL said, they declared, I consider every death of an American, British, or Dutch soldier as a victory. The AEL was accused of anti-Semitism by an agency of the Belgian government, and a Dutch General Intelligence and Security Services report about the AEL warned that a violent radical Islamic movement is gradually taking root in Dutch society. The problem is that it's not simply relegated to crazy jihadi NGOs that advance the case of demonizing Israel or promoting anti-Semitism or promoting anti-Americanism in European states. They're often supported by mainstream NGOs such as Human Rights Watch or Amnesty International that echo the same ideas that often these NGOs generate. And more, just a few years ago in New York, the Center for Constitutional Rights, along with the Palestinian Center for Human Rights, filed a civil lawsuit against Avi Dichter, the former director of Israel's General Security Service. These NGOs often are linked at a financial level because they often support one another. They're often formally linked, or they are financed by the same sources. CCR is supported by the Ford Foundation and George Soros's Open Society Foundation. And CCR also counts amongst its friends and allies the International Federation for Human Rights and the Palestinian Center for Human Rights. The Palestinian Center for Human Rights was working in close coordination with the AEL in terms of seeking to indict Israeli generals abroad. These NGOs were aided by, at the time, Belgian war crimes laws that would have allowed Belgian courts to pass judgments on charges of war crimes, crimes against humanity, and genocide, regardless of where the alleged acts took place or the nationality of the accused. Douglas Murray beforehand just mentioned about how senior members of previous US administrations have also been, these NGOs have sought to indict them with the same methodology. And Herman de Croo, president of the lower house of parliament, said, I expect any day a suit to be made against President Bush in Belgium. This, of course, happened against Colin Powell, Tommy Franks, Dick Cheney, also George Bush Sr., General Norman Schwarzkopf, for their roles in the 1991 Persian Gulf War. And Donald Rumsfeld at the time said that the US would have to withhold funding from any new NATO headquarters building in Belgium unless the matter was resolved. The fundamental point here is that civil society, which intended to bridge gaps between populations claiming that they were extensions of the democratic process. The democratic process is limited to the nation state. Civil society claimed to Peter Falk, he said civil society is extending the democratic process because often civil societal organizations, often in the form of NGOs, have representatives or claimed constituencies from across the board, from multiple states around the globe. The problem is that that sounds great in theory, but in practice, it doesn't necessarily complement the Westphalian state system, but seeks to undermine it. Trusted by the public nearly 2 to 1 to do what's right in comparison with government bodies. So what you're seeing at a localized level of lawfare, even at a state level of lawfare, is occurring at a multilateral level. And, on a policy level, I'm thinking to myself, the reason I haven't seen conservative organizations that care about reinforcing the identity of Westphalian state systems of the nation states, or Israel organizations, or Jewish organizations, or pro-US organizations, echoing the techniques which are wielded by these civil societal organizations. I wonder how many of my co-panelists, how many of their organizations are registered as NGOs, and they have the ability of operating at multilateral levels of the UN, and even infiltrate UN agencies and become official parts of UN agencies. This is something that I don't see happening, and we have to understand that in the current age which we're in, power has diffused, it's atomized. It's not simply at the apex of society in the form of politicians, policymakers, or think tanks, but it's also at a grassroots level, and I think that it's time that organizations that are represented here, or concerned members of the public who are attending this conference, start echoing the methodologies that these NGOs use.
So
Thank you very much.